delighted to have been invited to do this session. What was even more delightful was that we were allowed to pick our topic. So we are running with the topic of digital infrastructure. I confess that choice is in part driven by both of our shared interest in space technology, and a lot of what we won't be talking about today too much is solely on the space and the space mining and all of the futuritive side of that, but a bit more of the nuts and bolts of all of it. But without further ado, we'll roll into a bit of an introduction and a bit of background for the two of us. So Julia Dreosti, I'm partner at Clifford Chance. I'm delighted to introduce everyone to Eden Jardine as well, who many of you will already know, who is joining us from Cause. And to kick off, I'm going to ask Eden a few questions about her background and what she's been up to. And what is most exciting is that we've just dragged her back to the Southern Hemisphere from a number of years overseas. So Eden, keen to hear a bit more about your experience while you've been away.
Thanks, Julia. Hi, everyone. It's great to be here. So I have just returned home after 7 years overseas. I initially moved over to Germany to study my master's in international dispute resolution at Humboldt University in Berlin. I moved down to Frankfurt after a year and a half and worked with the White and Case team in their arbitration group. And then I jumped the pond in the middle of the pandemic, which is always a good time to move if you're ever thinking to do a complicated move. I highly recommend it. And I moved across to London, where I joined Le Live, a Swiss disputes firm focusing on international arbitration. And then I rolled across to Hogan Lovells, where I was focusing on investment treaty disputes with the team in London there.
That's a lot. It's very good to have you back, though. So what would you say was your career highlight so far? There's more to come, obviously.
I hope so. So far, I think winning my first arbitration case that I was involved in whilst at Le Live, we represented the Australian mining company Indiana Resources against Tanzania in an investment arbitration claim, and we were successful on all grounds. It was the first case where I was involved from start to finish, and I had a lot of first experiences while going through that case. So yeah, it was a very special case to win, and it was great to share that with the client as well, who was over the moon.
Absolutely. And so what are you focusing on now that you're back in Australia?
So now that I'm back home, I am still maintaining my arbitration practice, doing commercial and investment matters, also branching out into the litigation world, working on complex commercial litigation disputes, again, involving mining companies in the resource sector and mining sector, but also shareholder disputes, other company corporate disputes as well. And relatedly to today's topic, I'm also very interested, as you just mentioned, in space law, so hoping to continue that as well. But enough about me, time to ask questions to you, Julia. So as a partner at Clifford Chance, specialising in disputes across several areas, including aerospace, defence, construction and infrastructure, what are some of the most interesting challenges and opportunities that you face when dealing with these really highly specialised areas?
I think it's particularly the new technology that you see across all of the areas, and the fact that, and I'm speaking to a group that very much does the same in terms of working across different sectors, but it is that interesting both opportunity and challenge whenever you get into a matter that often it is very complex technology that you're needing to understand, in addition to obviously the legal overlay. But I think that is what keeps the job really exciting. And I think the other dimension to it is the procedural aspect, as you mentioned, in terms of coming back to Australia, that there's commonly that mix of doing arbitration, whether it's international or domestic or both, as well as litigation side. And I think that also gives an opportunity to see where you can adopt and use across the different forums, the sort of the best practice techniques as well. So I think that's the two best aspects of the job, in addition to the people, obviously.
Of course, people are always very important. But no, that sounds very interesting. So I'm sure that there's been times through all these different experiences where you've learned lots of lessons. Are there any that stand out that's good or bad that you've learned from working in these really exciting areas of law?
I think what I enjoy doing, and whether it's in the area of law or it's sort of some of the related fields like these industry bodies or some of the chambers of commerce, is when you get that interaction with the business side of companies across sectors, or the people working within units that are highly specialized, for example, highly specialized engineers. And I think that's the real takeaway, is seeing how they operate, and they're just as niche and just as focused as we are as arbitration practitioners. And I think that's probably the really valuable lesson that you learn on every matter, is that if you're curious enough, you're going to learn a lot about a very niche field, even if it won't necessarily be the most interesting dinner party conversation. It's fascinating while you're in it.
Absolutely. And I guess that depends. It's in the eye of the beholder. So it depends who you're sitting down having dinner with, whether they would agree if
True.
it's. But that's awesome. So in terms of space law, how did you, and digital infrastructure in general, I mean, you've just mentioned that you've been working with technical experts, engineers. How did your interest in this area kind of blossom to start with, and how does it fit into today's discussion?
So I think probably more, the tech is amazing, and it's really developing incredibly quickly, and it's so topical in terms of both the digital infrastructure piece that we'll come to later on, and we've seen examples in the news about all of that, and about the implications when it works and doesn't work very recently, obviously with what's been going on in Spain, and also looking at, I think overnight you've had Amazon launching finally their Project Kuiper satellites as well. So I think it's partly a topic that got me interested because it is so topical and current. The other element of it is that it's incredibly entrepreneurial. Our relevant space legislation has embodied in that legislation that it's about encouraging that entrepreneurship. And so I think it is that dimension, particularly with new space, that we're seeing in terms of big government actors, as well as your very large multinationals, all the way down to your tiny started in a garage startups that are creating this tech and that are engaged as well. And so I think that is what really got me excited about the space sector, is that it's obviously a new frontier, but it's a frontier where we're seeing disruption to a degree in a way that we don't necessarily see in other more conventional sectors. So that's what drew me in.
Completely understand that.
Yeah. So, but I think then if we sort of start moving into the context of what we're wanting to speak to all of you about today, and how it then translates into arbitration, the types of disputes we're seeing, is very much this piece about the significance of digital infrastructure. And fortuitously, was just listening to a podcast recently with the Brookfield CEO, who very rarely gives interviews, but was just giving some insights into their investment strategy. And obviously it's heavily focused on infrastructure, and they've got over $1 trillion under management. And the quote that stuck with me mainly was the observation that 50% of the things that Brookfield invests in today did not exist as an investment asset class for investors 20 years ago. So that's 50%, and Brookfield invests in the backbone of the global economy. And I think if we then translate it back to us, and I'm doing this in a very rudimentary way, but it does make you think, particularly for a lot of the people on this call that do infrastructure arbitrations, that means 50% of the types of infrastructure that are now going to disputes didn't necessarily exist 20 years ago, when a lot of us, not all of us, were practicing in the sector. And so I think that just gives some insights into how much the sector is developing, and necessarily how much the types of disputes we're looking at is also evolving. There was also very interesting observations made in that podcast in terms of where their focus was as also alternative asset managers, and that was very much on this digitalization of everything, and energy transition, and the deglobalization of industry. So they're three topics in and of themselves that we could spend hours on, but I think there's a really interesting overlay, particularly when we're talking about digital infrastructure. So that's really why Eden and I were keen to have this session today. And normally when we talk about space, we go from the ground up and we get to space at the end. We're going to flip that today. And Eden, very keen for you to just set the scene for us in terms of space and what the legal framework is there. And then we'll bring Lance down to earth in terms of digital infrastructure from orbit down to the ground.
Awesome. That sounds like a good game plan. So there's a number of different sources of law that can be relevant when dealing with space disputes. So we've got international treaties, national domestic laws, and when a dispute does go to arbitration, you've of course got your arbitration rules that govern those proceedings. But notably, there is a gap that seems to appear between international treaties and the domestic laws at the moment. And I'll briefly go through these. So there's 5 United Nations treaties on outer space. I'll very quickly just go through them in the interest of time. I don't want to bog ourselves down too much in these details, but we have the Outer Space Treaty that was entered into force in October 1967, and there's currently 115 countries or so that are party to the treaty. So there's a lot of signatories around the world that have joined this treaty, and it sets out a framework basically for international space law. So there's different requirements and responsibilities for the states, but one of them is that the states are responsible for their acts, which includes private companies. And Article 2 of this treaty says that there's no right to apportion the moon or other celestial bodies by use of occupation or any other means. So that is the Outer Space Treaty. There's also the Liability Convention, which is setting out the liability for any damage that's caused in space. Australia is a signatory to both of these treaties, I should point out. There's also the Moon Agreement that states that celestial bodies can only be used for peaceful purposes. Again, Australia is a signatory. And then there's the Rescue Convention and Registration Convention, which probably aren't as relevant for our purposes today. But in addition to these 5 UN treaties, we also have other international agreements, such as the Artemis Accords. And this was established in October 2020 by NASA, the US government, and 7 other initial signatory nations, Australia being one of them. And as of April 2025, so this month, there's 54 signatories that have been agreeing to this set of rules and common set of principles that the Accords aim to achieve. So interestingly, Section 10 of the Artemis Accords refers to space resources, and it seems to try to align this Article 2 of the 1967 Outer Space Treaty, which I mentioned before, that prohibits national appropriation of space resources on one hand, with our modern reality that we're dealing with at the moment, where there's a lot of private companies and startups that are in the space sector, as well as state players as well. And there's a growing appetite to explore space resources and being able to get their hands on this type of resource that are out in space. So very quickly, Section 10 states that the signatories affirm that the extraction of space resources do not inherently constitute national appropriation under Article 2 of the Outer Space Treaty. So that, in a very quick nutshell, is the international legal framework. And then there are national laws as well, which is treating this differently in different countries. So in America, citizens are lawfully allowed to obtain their own space mining resources, keep what they find, and there's other jurisdictions around the world that have followed suit. You've got Luxembourg, the United Arab Emirates, Japan. So they've all passed these domestic laws that allow citizens to have these property rights that they might extract in space. The Australian domestic law doesn't address this. We've got the Space Launches and Returns Act 2018, which does provide for regulating space activities, but it doesn't deal with the ownership of these space resources. So when you are comparing these two, what does come up is that you do have a bit of a tension between how some countries are being very open and positive about these space resources, being able to, obtain them and keep what they find. But then you've got other countries that don't have these same legal domestic laws in place. And if they're only a signatory to, say, the Outer Space Treaty, there's a bit of a disconnect between what's happening universally. I won't spend too much time on the arbitration rules. It depends, of course, on the case, but there are the PCA optional rules for outer space disputes. These offer flexible arbitration mechanisms if there was to be a space dispute resolved through these rules. To date, I'm unaware of any case that has actually used these rules yet, but with the prevalence of space disputes growing, this might happen in the near future. And of course, you've got exit, on-control rules that would apply where these related disputes come into play.
Good. And if we can bring you across then in terms of some of the cases that we're seeing in the sector, certainly there was obviously a study done a few years ago by McGill University that said in terms of dispute resolution clauses, the clauses were for arbitration in your sort of big satellite agreements and the space sector generally. So what's the sort of type of case you're seeing?
Yeah, exactly right, Julia. So as you would imagine, space disputes, it can arise from different types of disputes. You've got commercial disputes, investment treaty disputes that can come up. There's also state-to-state disputes. So as you rightly pointed out, the satellite industry has been having its the biggest involvement of these space disputes that we've been seeing, really. But there are other ones in addition to this. There can be disputes regarding insurance, supply agreements, partnership disputes. So there are different cases that can arise within the commercial space dispute sector. And then regarding investment arbitration, just to briefly touch on it, we know of at least 4 investment cases that have dealt with space disputes. None of these have come up very recently in the last 12 months, but they do illustrate that this is a possible avenue where disputes can come up and arise. And then just to round it off, to briefly touch on state-to-state disputes, again, there's no very recent cases that's happened in this area, but it is possible. And given the rise of all of these potential disputes, I think watch this space because anything's possible at this point.
Yeah, well, I mean, I think that's the point as well with new space, that you've got just so many more players than there were historically, that logically there's a flow of disputes that comes from that at different levels. So in terms of the cases that have been coming out, what does that show in terms of the challenges for the space sector?
Yeah, so I think there's many different challenges that do arise from those cases, as well as just facing the space sector in general. I touched on it before, the gaps in the legal frameworks. Does this breach, if, for example, space mining was to happen, and if one country is permitted to do this in their domestic courts, but then somebody in their own domestic courts is not, is there any breach of the Outer Space Treaty? What about the Moon Agreement? So there's all these legal questions here. But then there's also many other questions regarding, from a wider span, there's space debris and environmental responsibility questions, and there's the enforcement of awards. For example, if we're dealing with space assets, if there's something floating up in space and someone wanted to enforce against that asset, how would that happen? So that's a different way of looking at enforcement of arbitral awards. But yeah, I think there's many different issues that do come alive here. So yeah, I guess in this really fast-paced, moving, developing area, there are still a lot of questions that haven't been answered, but that's the exciting point.
And what do you think that means in terms of opportunities?
I think there's a lot of opportunities. That's the upshot of having all these different challenges and questions and unanswered areas. So there's a lot of international collaboration happening at the moment, which is really exciting. We're seeing this at industry level, and also, I mean, even this morning, Stephen Freeland, I saw a LinkedIn post saying that he's leading a working group on space resources, which is very exciting to see that there's discussion filling that gap. So there's lots of international collaboration. There's further development of soft law instruments that's happening. There's dedicated space arbitration centres that are starting to pop up. The first one was in Dubai. It's a very early step, but there's no reason why not these can't pop up elsewhere. So there's a lot of different opportunities, and it's really just the beginning. So it's an exciting time to be a part of it all. But speaking of new and exciting opportunities, Julia, is there anything else you would like to add from your side?
I think, well, conveniently, the news helped me because Amazon, as I mentioned, just launched the first lot of their satellites for Project Kuiper, which will be what will compete with SpaceX for Starlink. And that's that constellation of satellites that's sitting in low Earth orbit, so the closest orbit to Earth. And what that really brings is global connectivity for all. And I know the ICC is one of many institutions that has written white papers on that issue. And so I think that is incredibly exciting that is what we will see. That's one of the benefits from that digital infrastructure in space, is that it means wherever you are, no matter how remote in the world, obviously cost permitting, that there is that scope for connectivity. So I think that's the most exciting thing that we're seeing. There's obviously all of those tensions that the tech is moving much faster than the regulators. As you mentioned, it's fabulous having Australians like Professor Stephen Freeland co-chairing that working group for the UN, but will it be able to move fast enough to regulate when we've already got landings on the moon to try to be taking samples to make sure that we do that in a sustainable way. So that's probably a lot of where the excitement is. I think the other one is the potential for data centers, obviously a core piece of digital infrastructure terrestrially, the scope for them to also be in space, where you've then got an endless power supply and other advantages. And that's something that Thales Alenia has been doing together with the European Commission, as well as private entities elsewhere have been looking at. So I think it's that real potential for massive leaps forward for digital infrastructure by really making the most of space.
Absolutely. And I think that's your segue for taking us through the digital infrastructure and the issues that we're kind of seeing closer to home.
It is. It's my magnificently clunky segue that we're now going to take it down to earth and talk about something that I think probably for everyone on this call, they're probably seeing more of in their day-to-day in terms of disputes, which is your data centers around the world. A quick recap, had looked for AWS in terms of what they give as a definition of a data center. So it's a physical location that stores computing machines and their related hardware equipment. It contains the computing infrastructure that IT systems require, such as servers, data storage drivers, and network equipment. It is the physical facility that stores any company's digital data. And the thing that is just so phenomenal about data centers is just the scale of demand and growth that we're seeing globally, and also that interconnection with the energy transition because of the huge demands that they have for power. So in terms of some of the stats, Allied Market Research predicts that the market value will reach $6.8 trillion by 2032. Particularly in the US, we've got massive examples of the data center projects. I think the Stargate project is going to be investing $500 billion over the next 4 years, building that infrastructure in the US, and we've got that sort of government support both there and elsewhere. So what's to look at then, and I suppose from our perspective as dispute practitioners, is what are the risks? Where might this come unstuck? Where are we getting involved to try and resolve those disputes, or if they can't be resolved at the project level, the escalation through formal dispute resolution and arbitration. And there's probably half a dozen that I just want to really quickly touch on. So you've got the construction risks in terms of this is a lot of high-tech equipment. You've also got some of your cloud computing that's involved in there as well, and the risk that you've got inexperienced contractors in doing the setup for that tech, which necessarily leads to your delays and defects. There's supply chain constraints. We've seen that for a lot of aspects of data center projects, and also the connection delays, because there is just so much demand, and some of that is demand onto transmission systems and services that are struggling to catch up and keep up. There's also that potential issue in terms of the market dynamics. The huge demand side means that you're then going to have sometimes a difficult landlord-tenant relationship, where it's the landlord that might have all of the bargaining power unless you're dealing with a hyperscaler. And so that's then also a risk for those sort of lease tenancy type disputes. There's obviously a huge geopolitical dimension to this as well, and that was one of those comments, I think, as I mentioned at the start, that is a big theme in terms of that reindustrialization and that importance of a sovereign capability, and that extends obviously in terms of when you're talking about data centers as well, and also some of the parts that are needed for those data centers, semiconductors being a good example. Linked to that is also the data localization piece in terms of some of those quite strict requirements that can vary between countries as well, and some of the pitfalls and risks for companies that are operating at a multinational level in terms of making sure that they are compliant wherever they are. And those requirements can vary considerably, but they're also understandably can be incredibly strict, given the nature of some of the data. One of the other ones, and obviously a lot of the disputes that we do are on the M&A side, in terms of there has been, understandably, given this need and the opportunities, a huge influx of private equity and funds into this space, and that increased M&A activity. And in terms of the disputes that fall out of that, they're everything that you would see in terms of some of your other M&A investment disputes as well, in terms of issues around exits or regulatory challenges or other integration issues. So they're very much on the radar as well. But I think the one that is particularly interesting, and again, that overlap with energy transition, is just in terms of the power demands. On this, Goldman Sachs done a really interesting study with a few good stats in terms of power demand. A chat GPT search is the equivalent of 10 Google searches. So just the scale of it, and you imagine that's growing, and particularly where you've got the AI aspect to that now, and that capacity for some of these searches to be generating videos. I think it's then 100 times that. And that power demand is expected to grow by a further 160% by 2030.
Wow.
I think, yeah, it's big on a scale that is extraordinary. And I think currently the consumption for data centers is 1 to 2% of global power. But again, that's also on the up. So it is that really challenging aspect for some of these very big data centers in terms of how they source reliable, secure power supply. That's a big aspect. Obviously, there's the ISDS dimension as well, in terms of where the opportunities are and the associated political risks or instability that can arise from that, which means, no doubt, like everyone on the call, giving that advice in terms of appropriate treaty planning, and being aware of the protections that are then available through those treaty mechanisms for further down the line. So that's kind of a very quick canter through just some of the issues for the sector.
Amazing. There's so many, and there's some very big numbers that you just mentioned. So yeah, it just really goes to show how big this monster is and will continue to be. So Julia, what are you seeing for the role of arbitration on these issues? Where do you think its role fits in?
Well, I think our role in this sector is the same in all the sectors that obviously arbitration's always operated in, and it's a neat fit in terms of, as we said earlier, infrastructure has always been such a big piece of the pie when you're looking at the sectors that use arbitration, and it's well suited again for these types of digital infrastructure disputes, because commonly you're going to have the cross-border element. So your first key aspect of enforceability is then ticked. You can have the benefit of subject matter experts, a tailored process if everyone conducts themselves appropriately and in the spirit of the rules, which can be hugely attractive given the numbers that are at play and the desire for a speedy resolution. There's also the confidentiality component, which is really important, obviously, given a lot of the data and the tech and the IP aspects of these data center disputes. So in particular, I think that is a real attraction if the appropriate safeguards can be put in place. But certainly disputes that have been on in the sector, it's a key element of it, is safeguarding that data, particularly if you've got government or other involvement. So the short answer is we're seeing these disputes and we can only think that they will continue to evolve. So it's a really good opportunity for arbitration practitioners to be in there and at the forefront of it, and also making sure, particularly for the space sector, that we are continuing to educate the space companies as well, just as much in terms of the benefits of arbitration over other types of dispute resolution. Sky's the limit, basically.
Completely agree. That's a very good way to sum it up as well. The sky really is the limit. That's, yeah, excellent. I mean, in terms of concluding thoughts, I guess I would essentially say that everything, echoing what you've just said, Julia, everything is moving really quickly. It's an exciting time. There's still lots of open questions, but there's plenty of opportunities. And yeah, echoing what you said, the sky's the limit. So let's see what's going to happen next. But also exciting time for arbitration practitioners as well, in particular to everyone on the call, because it is definitely going to be a notable sector moving forward, and it's a good time to get across it.
And now we're going to test the tech, because we're going to see if hopefully Emily can join us.
Yes, thank you. Do you hear me?
Yes.
Yes.
Great, thank you. When in doubt, switch to your mobile phone. Thank you so much, ladies. This was really, really interesting, and I think certainly extremely relevant. I know I myself am seeing more and more satellite disputes come up, and I think this is really partly due to some of the benefits that Julia just mentioned of convincing also space industry that it's worthwhile to insert arbitration clauses in their contracts. And I think we're seeing the results of that already. So it's a really good opportunity to get our heads around it as well. And I'm going to open up the floor in case anyone has any questions arising from Julia or Eden's presentations. Anyone, please feel free, because I can't see the chat here. So you can unmute yourself and just ask your question directly. Doug.
There was a very interesting debate in Vienna at a conference in the margins of the Wismut about green arbitration, where it was said that if you put all your documents in the cloud, you are consuming far more energy than if you had a hard copy bundle for the hearing.
I would say that the tech is developing, and that might be a good debate this year, but not next year, I would like to think.
Well, it was interesting. I'd never thought of it, but it obviously is relevant. I mean, I'm certainly seeing a significant number of data center disputes in arbitration where there's a disconnect between the ultimate user, the owner, and the service provider of the center. And I also had a fascinating dispute in Iceland involving a battle between the aluminium industry and the data center industry, with the data centers being prepared to pay a lot more money for energy, which was limited in Iceland. And so it was a battle about trying to get out of a long-term energy supply agreement.
Interesting. And Eden and Julia, in the Australian context, where are parties coming from, if they're coming from abroad as well as domestically, are you seeing particular regions involved in either the space tech or the terrestrial?
I mean, I think on the space tech side, we've obviously got AUKUS, which is in its own process, but it means that certainly from those parts of the world, that's probably where we're seeing the interest coming into Australia. I think on data centers, it's broader than that, but there is a lot of activity. But I look a huge amount of activity, and then you look at sort of the investments made in the US, and it seems quite small, or at least a large gap to catch up on. But certainly, the energy's going there, and the influx coming to make sure that it catches up, given the population densities.
Interesting. Okay. Does anyone else have a question? Please feel free to unmute yourself.
I would like to thank you very much for the presentation, which was very interesting. I haven't done any work in this area. I was wondering if any issues of arbitrability have come up, as for instance in competition law, antitrust and so on, whether you have seen issues arising with respect to arbitrability in space arbitration, space law arbitration.
So I haven't seen any, but I agree with you in terms of there are those risks in sort of the age-old debate in terms of some of your antitrust aspects or some of the IP dimensions to it. It's not something that I've seen, but I agree with you, Andrew. There is scope for some of that to be an issue.
I also agree with you Julia. I haven't seen it myself, but particularly in IP with the arbitrability issues that can arise, it's very possible that in the future there might be arbitrability issues. So it'll be interesting to see what unfolds.
They could be run.
It may also be dealt with in the white paper of the ICC that you referred to, but I haven't read that paper.
That was actually, so that wasn't Court of Arbitration side, that was broader ICC side in terms of connectivity and the importance of that greater access globally. But no, I don't think it was addressed in there. There you go, Andrew. There's a project.
Thank you. Thanks.
Anybody else? Great. If we don't have further questions, then that leaves me to thank you very much, Julia and Eden. I think this was a super interesting lesson and we all learned a lot today. So thank you for sharing your insights and your experience. And thank you everyone for joining us. It was great to see you. And we'll have our next episode of Conversations with ICC Australia at the end of May, and the details will be announced very shortly. Thank you everyone, and wishing you a great day.
Thanks, Emily. Lovely to see everyone.
Thanks very much, Emily. Thank you.
Thank you.